Hello everyone, welcome to our podcast session on Let's Talk Law.
I'm Elaine.
I'm Eugene, and today we have Kenneth from BR Law to share with us legal questions and answers related to property.
Very happy to be here. Thank you.
Okay, so today we have a few questions, taken from our buyers and our colleagues, for Kenneth.
The first question, buyer cannot decide yet to use full cash or take up a housing loan. When is the latest for them to decide and inform law firm should they decided to take up a housing loan?
That's a good question. So, generally speaking, what we always like to remind clients is that the process of disbursing the bank loan for you is not like you going to an ATM machine and just punching in the numbers and the money comes out. Okay, there is that certain dedicated process which takes time. And generally, from our experience, from the signing of the loan till the disbursement of the loan, generally 8 weeks, to a minimum of maybe around 7 to 6 weeks would be the minimum time that is necessary in order for us to disburse the loan without any sort of drama. Yeah, anything shorter than that, then it might be more difficult because the process of disbursing the loan involves a few things. From the day in which you as the client, you actually accept the loan and you sign off on the loan offer, it starts this process whereby that offer is batched down to the bank's credit department. From the bank's credit department, they activate the process whereby sometimes they require valuers to value the property. Okay, and they also need to send something called a letter of instruction to formally appoint the law firm to act for the bank in this process. So all of this takes time. So rule of thumb, without going into too much detail about some of the background work, which generally is not that relevant to the client, the entire process, as I mentioned earlier, takes around 6 to 8 weeks from when the loan is signed.
Question 2. HDB owner keen to purchase Springleaf Residence, for example.
Yes.
Without incurring ABSD,
Yes.
after granting an OTP for their HDB and the buyers of the HDB have exercised the OTP, are the HDB owners free from ABSD on the purchase, or do they have to wait for HDB approval letter?
We all know that ABSD is very heavy these days. So the start of the process, there is two parts to it. So generally speaking, IRA's position, and this is something that you can even see on IRA's website, is that from the day in which the HDB option is exercised by the buyer, that frees up the HDB owner, the HDB seller, from stamp duty liability. However, what you know and I know is that exercise of the HDB option is only the start of a process. Okay, there is this approval that will still be pending, whether HDB allows this transaction to proceed. This could be because of loan eligibility. It could also be because of the quota, and some of these reasons. The deal is to sell the HDB is on much firmer footing only after they have gotten and received HDB approval. That's when you know with, I would say, 99% certainty that the HDB can be sold, to the new buyer, and that the new buyer will have the ability to proceed with the purchase. So one of the issues that arise and why there is this industry advice that, you might want to wait for your HDB approval before you proceed, is because at that point of time, then there is that greater degree of security and surety that your transaction will proceed. And also, I think as a very practical matter, generally the maximum deposit for you to exercise a HDB option, we know, is only $5,000. So $5,000 in the macro of things, is not a very large sum. So, and there are also HDB buyers who exercise with a much lower deposit They might do $1,000 upfront and then $1,000 again also. So if you are just relying upon the exercise of the HDB option, there are some of these variables which are still uncertain. And what this uncertainty could lead to are some potentially negative consequences. There was this case that we had for this client. The buyer was very sincere, okay, and exercised the HDB option, okay, which my client who was selling the HDB and wanted to buy a new launch. So the new launch was around 2 million. The HDB was sold for less than $1 million. So the buyer was very sincere and proceeded, told them that don't worry, my paperwork is all in order. But ultimately, there was some issues in relation to their eligibility. It was not within their control. It was not because the buyer was frivolous. It was just because there was something that occurred which was not within their control, and they didn't get the approval to proceed with the purchase of the HDB. So in such a case, it is very hard to attribute liability towards the buyer, because the buyer can put forward the position that, brother, it's not I don't want to buy from you.
Yeah.
It's HDB don't allow me to buy.
Yeah.
This is not within my control.
Mhm.
So there is no element of so-called fault on their end. So what happened to my client, who was both selling the HDB and trying to buy the new property purchase, the new launch, is that, hey, suddenly when he approached me, I told him, oh dear, that means that you are liable for ABSD, okay, on your second property.
Right.
Okay, you're liable for 20% ABSD, which based on their 2 million property value is $400,000. Okay, there was ultimately a somewhat happy ending to this. Okay, because what we managed to do is that we managed to assist the client to write in to IRAS. Okay, and IRAS basically in that particular case, okay, they always like to caveat the situations that they say, oh, on a case-by-case basis. So on this case, what we will do is that we understand this situation. Please proceed to quickly remarket your HDB. Okay, so my client managed to find another buyer who managed to successfully proceed to exercise the HDB option. But on the part of IRAS, they said that, okay, good, you have informed us that, you have managed to successfully sell your HDB again, and it seems like this time round it will complete. So, however, on our end, from IRA's position, they will still have to charge the client, okay, late interest in relation to the stamp duty that was payable. They were kind enough to not impose the full stamp duty and require them to make payment before allowing that remission. Because what happened in this case was that the new purchase of the new launch was also done, fortunately, under both the husband and the wife's name. So there is also that possibility of remission. Okay, and IRAS in this particular case, they exercise their discretion, okay, not to require payment of the 400,000 ABSD, okay, before remitting it, and instead just charging interest based on that 400,000 until such time that the other HDB was sold. Okay, but of course, I should point out that this is absolutely discretionary on the side of IRAS. It's always on the individual case-by-case basis. Okay, and generally speaking, Section 33A of the Stamp Duties Act, IRAS have unfettered discretion on how they wish to impose the stamp duties that are payable in all of these circumstances.
Okay.
Yeah. Earlier on, you say that they pay the interest is
Yes.
due to the late payment of the stamp duty.
Correct. And of course, the clients in that particular instance, they had no financial capacity to come up with that 400,000. So we were very worried because you are literally caught in in a rock and a hard place, because IRAS could hold the view that you pay me the 400,000 first, okay, then I allow the remission.
Right.
Okay, then if that's the case, then the client will be will be stuck lah.
400K is
Correct. It's not a small sum.
Yes.
Correct. And also another thing to note is this, because in a worst case scenario, okay, if they didn't manage to successfully sell on their HDB, what could happen is that there could be a situation whereby they have to forfeit the private property, the new launch that they have purchased.
So there will be a forfeiture fee.
Correct. And for private BUC, for building under construction, for a new launch, generally the forfeiture after you have exercised is 20% of the purchase price.
the exercise.
Yes, correct. So potentially, you are like, I owe IRAS 400,000. I want to sell off or not proceed with this purchase. The developer takes another 400,000 from me. Wow.
That's right.
Yeah.
So need to be very careful on
Yes.
this. Yes.
Correct.
Okay, very interesting case study. Yeah?
Okay, the next question is what happened if after they go ahead to purchase a Springleaf Residence and then the HDB reject the resale application for whatever reasons? Are they able to get a refund of the booking fee for the new purchase?
Even though this question sounds similar to
Exactly.
the
Yes.
previous question in which I've answered, actually the nuance of this question is slightly different. So it depends on whether you have exercised the sale and purchase agreement or not.
Right.
Because generally speaking, if you haven't exercised the sale and purchase agreement with the developer, you still have the option to not proceed with the purchase. Then your forfeiture, even after having put down the deposit of the 5%, is only 1.25%, okay, of the total purchase price. But as I mentioned earlier on, if you have already exercised,
That's a different.
okay, then it's a different quantum altogether. Then it becomes 20% of the purchase price. So if you haven't exercised yet, then your refund of the booking fee is going to be a much smaller quantum. If you have already exercised, then
Huge.
legally speaking, okay, you are liable for a very large sum, 20% of the purchase price. What some clients therefore do is that sometimes they ask for that extension of time,
Yes.
okay, to exercise the sale and purchase agreement, okay, and depending upon the circumstances, sometimes the controller of housing, which governs, when the sale and purchase agreement must be exercised by, sometimes they do give you that additional period of time. But then controller of housing only reply to this request only based upon documents. So that means that if you are writing to the controller of housing and requesting for that delay to exercise your sale and purchase agreement, then you must give them signed documents. So in this case, for example, you must have an exercised option, okay, to sell your HDB. With that, you can write to ask for the extension of time. And must be an exercise. It cannot be just an issued option. Sometimes there is this nuance that the client needs to understand.
What about besides selling another like HDB to prove
Yes.
that they are selling? What about other reason to delay the 15%? Like maybe like I need time to transfer my funds over from overseas.
In relation to some of the reasons that we have written in to the controller of housing, okay, I think one of the more memorable ones was what we call the feng shui case, because the client is a great believer, okay, on numerology and feng shui, and was very insistent that I only want to exercise my sale and purchase agreement on this date,
Right.
which was out of that 3-week window that
Right.
that
Can this be
that
the
is
reason?
allowed. We had one case, okay, in which very fortuitously, so it shows his feng shui was on spot, okay, in which it was allowed.
Wow.
But thereafter, okay, there was another client who preferred the same reason and it was rejected. So
it
so
depends.
it depends.
Right. Depends how powerful your master is.
likely, yeah. And I think apart from I mean, jokes aside, okay, there are some of these instances whereby the clients are literally still overseas. And what they have done is that they've shown us their itinerary and they've shown us that, oh, I'm only returning on this date, and we have also used that as a basis to write to the developer and to the controller of housing to request for an extension of time to exercise. Yeah.
Right.
And the other parts are like, for example, if you have a fixed deposit that's only maturing on a certain date, we have written in on those requests before. But the ones that generally gain the most traction, with the high, I would say the highest percentage of positive replies from controller of housing usually revolve around the sale of your property. And because you are selling your property and you're expecting a certain amount of money to come in to fund the new purchase, therefore you're asking for that extension of time to exercise.
Right.
And I think sometimes it is a little prudent because, as I mentioned earlier, if you rush to exercise when your property is not fully sold yet, then sometimes you are caught in a double quandary.
Right. Yeah.
Government will ask you for money, and then also you still you also lose the new house. That's sometimes something that's quite scary
Right.
if you think about it.
So that means actually buyers need to be ready with all the documents, and any special cases are all case to case,
Correct.
case basis lah.
So we always have this saying to clients. They always ask us, what is my worst case scenario? Then when we look at them, and then suddenly the agent beside the client was sort of like, look at me and run a bit cold and sort of like, break that cold sweat. And they sort of like, well, I can tell you a lot of very, very worst case scenarios, Yeah, but I think the worst case scenario is the one that I mentioned, that, you proceed to buy a new house and then suddenly you're liable for ABSD to the government, and at the same time, you cannot proceed to complete the purchase and you also lose the house.
Right.
So I think that's I would dare say is one of the worst case scenarios.
Okay, so let's hope our buyers don't get caught in this situation.
We have come to the end of today's session. If you would like to engage Candice for more legal advice on your property matters, please contact him at the number or scan the QR code to reach him.